Okay, good morning, everybody. My name is Lodewijk Pinaar, Advocate Lodewijk Pinaar then from LabCo Employees Organization. Welcome to this webinar for the 17th of February. This PowerPoint, as well as if you would like the recording, will be available later. I'm just reminding all the participants that this is recorded. Therefore, if you would not like your video or your face to be recorded, please switch off your video so that we can protect your privacy while we are busy discussing the protection of personal information. So, what is the protection of personal information? The purpose of protection of personal information is to protect personal information and the privacy of people. Now, one of the questions I get, why would a labor organization be interested and or give recommendations in regards to this? The reason is each of our clients, when you look at the definition of what is personal information, you get personal information and special personal information. And special personal information is my name, my ID number, my union affiliation, my race, my gender, all of those data that as employers we need to collect in order to give it through for our skills development or for our BEE. So we are definitely dealing not only with normal information, but with special information. And therefore it is of the utmost importance that from a labor perspective or as a labor organization that we give through the correct data and way to utilize this. Now, South Africa's Personal Protection of Information, or POPIA Act, is then the South African version of what is referred to as the GDPR in the European Union, the General Data Protection Regulator. We, as South Africans, I do not know why, we are the only country that not only imposed serious fines, but they, as legislator in South Africa, has decided to criminalize the non-compliance with this. So it is not only a compliance issue, but also a criminal act, something that nobody would like to be part of. When I looked at this, I found compliance to be perhaps a stumbling block in doing business, but there are certain compliances that we do not have choices with. And one of them would be SARS. We have no choice but to do business with SARS, but on a higher end, if you have a certain turnover, then VAT kicks in. So in compliance, there's always the basic compliance and then the higher compliance. With BEE, yes, there is compliance, but then there's higher compliance once you've reached a specific turnover or 50 staff members. With health and safety, you need to comply, but once you reach 20 employees or more, then certain specific regulations kicks into place. And with COVID regulations, if you have less than 50 employees, yes, you need to comply, but if you have more than 50 employees, there are very specifics that you need to comply with. If on any of the above you have queries, please contact us. But POPI is interesting. POPI starts from Rand 1, Business 1, so there's no basic compliance or higher compliance. You need to comply regardless of size, and you need to comply fully regardless of size. I find that difficult, specifically for smaller clients. As an advocate and as a legal practitioner, I've always held the principle of KISS. Keep it simple and short. And therefore, we've spent a lot of time working through all the fluff, what is required, and what we are presenting here today would be a very focused approach to make sure that you do comply with the, I don't want to say minimum because that sounds like we're slacking off, but what is required of you to comply? Because to spend boatloads of money on this, and to comply to the umpteenth degree would serve no purpose if you could comply with something less. So with the disciplines of law, which is on my side, the disciplines of finance and phase and figure on Chanzel's side, and with practical experience, we've really spent a lot of time. And what we are presenting here today would be, of course, the background, and then how do I comply without breaking the bank or spending too much time on this. With that, let's dig in. So the role players of POPI, I know it's POPIA, but it's more referred to as POPI. And I'm going to take the employer again. So the data subject would be the employee that completed a contract or anything else, a union membership, whatever the case may be. The responsible party will be the employer through the CEO or any other agent, and the operator would be the agent. Let's say your HR department, your payroll department, whatever the case may be. So an information officer must be registered. So each company will, as you have with health and safety, where there is a responsible person, and by the way, health and safety can also lead to criminal prosecution. So as you would have on the health and safety side, you need to appoint by law an information officer. That information officer for a public or a private body must be appointed and carries the obligations of that entity to comply with this act. That information officer is an ID number. It is a natural person, a real breathing, living person, because you can't lock up juristic persons. You can only lock up and criminally prosecute real live people. So an information officer must look after the data subject, the responsible party, and the operator, but that information officer may also appoint an assistant or assistant of information officers, and that is where we could provide or be of some service. So who does POPI apply to? I've already said when it comes to other compliance, there are different levels, but there is no level when it comes to POPI. So it's sole proprietorships. If you are a natural person and in your personal capacity, you trade, that's a sole proprietor. A partnership or a company, private corporations or incorporations, and here's the scary one, non-profit organizations, trade unions, and public bodies. Now, once I did this test on myself, I found that not only do I have a few private companies that I own and or am the director of, but I also serve on a few non-profit boards and even boards in partnerships and bigger companies. So as a responsible person, I would have to make sure that all of those companies comply. I've spent a lot of time to think how they are going to police this. And it is actually very, very simple. How are they going to police this? The Registrar of Companies, or CIPRO, carries, of course, all registered companies and the ID numbers of people combined with SARS. So because you need to file very specific documentations with the registrar, they will be able to track and trace and see which companies did not file. What they filed is a different question, but which companies did not file. And once they see who the directors and then the ID numbers of those companies are, they will simply do a search and see which other companies are also linked to your ID number. And if you are found to be the responsible person, whether you registered yourself as the information officer or not, you will be held accountable for whatever comes down the line. So in my case, I need to comply 5 times with the POPI. I need to register myself with all 5 entities as the information officer. I need to file 5 plans to make sure that I comply with POPI, 1 for each entity including those non-profit organizations that I'm part of. I'm going to hand over to Chanzel just to give us a brief background as to the timeline of POPI. Chanzel?
Hello, everybody. Okay, the timeline of POPI started way back in 2013 already. That is when the law was signed into. And then in December 2016, the information regulator got assigned. He took his office. It was then published in the Gazette in December 2018, 2 years later. And then July 2020, the POPI Act took into place, the effective date. That is when we all started wondering, what is this POPI that everybody is going on about? So by March 2021, which is less than half a month to go, every company needs to have an information regulator. We need to register somebody that is going to be taking responsibility for that. And then each company needs to be able to give proof that they are POPI compliant before the end of June. So cutoff date 1 July. So we've got less than 3-4 months, and every company needs to be compliant. So that's quite a lot of work that small companies, large companies need to do before then.
Chanzel, if I could just ask you, the end of March registration, would that now be for the information officer to indicate who the responsible information officer is?
Yes. Yes.
Okay. So we'll get to that. So here's the penalties and the fines, and I'll take us through it.
Okay. Then the penalties. These are all the penalties if we are not compliant. And the scary thing is it's not your business, your company that is going to get penalized. It's you as the responsible person, you as the director or CEO of the company. So if we aren't compliant, we will get a 10 million and or 10 years in prison fine if we are not compliant for POPI. As I say again, it's not the company, it's basically the CEO, the responsible person of that company.
Thank you. Before I get to who is the information officer, I know this is a daunting prospect, but the only good and upside of this is the fact that those spam calls, and I'm sure that it has kicked up on your side in your personal capacity as it has with mine, everybody is selling their last piece of data to you. And that is exactly what this is supposed to curb, those spam calls where you did not give your number. I will prepare also as part of this a WhatsApp, SMS, email response that you can just keep on your phone, and whenever you get a spam call or a spam email or a spam SMS, you can just reply and just remind them, guys, in terms of the POPI Act, I'm giving you instruction to remove me from, or purge, if that's the right word, to purge me from your system and never contact me again. Otherwise, I am going to report you to the registrar. So that's the only upside of this. So who is the information officer? Well, it needs to be an employee of the business, and therefore CEOs are employees of the business. Preferably it's a manager, so they are looking for a person in authority, a person that can not only see the challenges, but also fix the challenges to make them compliant, and they must be a South African citizen. So if you have a company, if you serve on a German, American, whatever company, it will be the highest ranking South African within that organization, and not the expat that has been sent here from that specific country to deal with it, because expats can't be arrested or pay those fines. So certain people, by virtue of their positions, are automatically appointed as information officers. Now, just to say, you must register. if you get audited or hit or hacked or there's a break-in, and then from there flows the investigation, the registrar will keep you automatically responsible, and the first fine will already drop because you did not register a information officer, but you are automatically being held responsible. So for sole proprietors, it's rather easy. This will be now the person, the ID number that runs the company. Otherwise, it will be the CEO, the managing director or equivalent officer, or any other person duly authorized by that officer in the closed corporation. So choose your information officer and make sure that he or she in writing understands the duties. If you do not appoint, the fines already indicate, and they are absolutely draconian. I know this is the high-level fine, but it's 50,000 for each compliance letter that they write to you. So the information officer's duties would, of course, be to encourage compliance. That would mean to understand what needs to be complied with, dealing with requests made by data subjects and process those requests. So that letter that I sent, please purge me from your system. If they do not purge you, and I'm not looking to drop names, but let's say some insurance company phones you later, you will then phone that entity and say, I want to speak to your information officer, and lay a formal complaint because I was not purged. And that information officer must have the savvy to know, how do you purge someone from my system? So that information, or your internal information officer, will be working with the regulator in relation to investigations and then ensuring compliance. And that would be his duties. The Act does allow for the appointment of or assistant information officers. Of course, we could provide those services, or that will be someone within your organization, but the information officer remains responsible. So here's the action plan that we have derived to comply with this. So stage one, we have set out an online POPI assessment. It doesn't take long, but it takes you all through all the fields, and in your specific company, you will tick what is applicable to you and what is not applicable to you. Interesting, one of the areas would be your website. If you have an e-commerce website where I can purchase goods and pay for goods, you would fall into a different category than a person like myself that has a website, but it's got no purchasing power. It's simply just to attract more business. After that, you also complete the online cyber checklist form. Based on what the Act then looks at, we will provide you with a preliminary report on both your cyber and schedule a date and time for inspection for your real life. Because if you need to be inspected, are there locks on the doors to protect the contracts of employment? Where are you keeping your backups? Are they kept in the top drawer, or are they being locked away? What software are you utilizing if you do cloud backups, so that we can provide a complete report to you and recommend where things should improve and where you know that you are okay. And then, of course, you receive a final inspection report. I'm going to give back to Chanzel for the compliance framework.
Okay, so the compliance framework works in 4 different steps. So basically, the first step is your privacy policy and your notices. Second step, your data subject rights. So what are their rights? The third step is your processes and change management that you need to change. And the fourth step is your data and your security.
Chanzel, these 4 areas, who identified these 4 areas?
Sorry, to say again.
These 4 areas, who decided what these 4 areas would be?
That is in the Acts directly.
Okay, no problem. Thank you.
Okay, so this is just a breakdown of it. So your privacy and policy notices is that needs to change in your policies, notices, partner agreements, customer agreements. So if I can just take for an example on your websites, you need to have policies in place for your websites, emails that's going out to clients, your agreements needs to change to protect your clients' rights. Then your privacy rights management is your consumer rights request, your direct marketing, verification, and your reporting. So you cannot go anymore and basically send out hundreds of SMSs to do direct marketing to clients. That's no longer what we are allowed to do because of POPI. Then the processes and changes of the management is your information officer, your governance, your training, and your audit and documentation. So you need to provide the proper training for your employees that they understand what is POPI and how do they help to get your company POPI compliant. And then your data and security is your data inventories, data security, periodic assessments, and your data lookup. So basically everything on your PCs, you need to make sure that they are protected by passwords, by just that specific employees that are allowed to have access to that data.
Thank you, Shamsa. Now, if you look at the different policies, once you are compliant, the privacy policy and notices, at the end of an assessment, you will have one and or a combination of the following policies that you will have to draft, adopt, and implement. Now, the first one would be a POPI policy. And that is a high-level policy that the framework thereof is provided for in the Act. Having gone through all of that and having gone through quite a lot of inspections, we have found that that one policy refers to various other policies that you need to draft and adapt and adopt within your company. So you would have a website or email privacy policy, a user access password policy, a server access policy, a network access policy, a remote access policy, or then also working from home policy, a use your own device policy. Now that's an interesting one. If not all laptops, PCs, cell phones are company property, and employees are knowingly or unknowingly to assist, has created their work email and that is being handled on their private device, how can we assure that that information is being kept secure? Also, your data disaster recovery policy. So all of these would have to be drafted and adopted. And this is what, once there is an inspection, that is how the registrar will look at your company, and this is what they will see on their side. Of course, not of course, this is part of the information. All contracts of employment will have to be amended to say, of course, I am collecting personal data as well as special personal information because you are an employee, and they must authorize you to keep that information. And then their unions and whoever they want will have to look at whatever policy would be applicable to them. All your civil contracts, tenders, etc., would also have to carry a clause to indicate that employees or clients consent to the fact, or at least know to the fact, that you are keeping personal information. All this is, of course, common knowledge, but you need that in writing. So the privacy policy template. This is what this POPI policy will have to entail besides the specific policies. First of all, it must be readable. It must address the purpose why data is being collected. Now, in a company, of course, I need to collect the data, including working hours, so I can pay the employees. The sources of data collection, the categories of data collection, as I said, the special ones and the normal ones, direct marketing. I trust that very few of us do that. So that would be the great part of this, to curb the direct marketing and this third-party sharing. Now, third-party sharing can, of course, be your database in regards to direct marketing. That would definitely be a third-party sharing. But if you outsource your payroll, you are sharing with a third party. So you'd have to close that gap and make sure that your service provider, which would have include LabCo, you are sharing court cases with me and problems and warning forms. So you are sharing third-party data with me. So I would have to supply you with my privacy policy so that you can be, at least from the regulator's point of view, know that the data you are sharing with me is not being sold out there. New customer rights, direct marketing, you must have an opt-in, opt-out option, great stuff for me. Right to access, right to know, right to delete, object to processing, and then the appeal rejection to access process. What this comes down to, the insurance company, I ask them to opt out. I want to know where they got my data. They need to tell me how they got my data. I've got the right to ask them to delete my contact details. It's actually called purge, because it can't just go to a backup, it must be purged. And then I can object to the fact that you are processing my private data. That's going to be interesting. So we'll see what unions do with us there. The risk of privacy breaches. Now, besides the fact that the policing will be done electronically and they can track and trace your ID number and those entities that you are linked to and see what you have filed, there is, of course, the penalties that go from 500,000 to 40 million if you are found to be willingly in breach. And I think that would be the direct marketing guys would definitely have to look out for this. So I would have to notify my customers if there was a privacy breach. I need to notify my customers. I need to notify my employees. I need to notify. Then there will be an investigator from the regulator. So if your website gets hacked and information is lost, or a laptop got stolen that was not password protected, or an external hard drive with information, I would have to notify those people on that data bundle that their information is out there. Then there will be an investigator from the regulator, and then there will be a business recovery where you will recover that information and or purge it from your system and recreate the information. So this is the risk of privacy breaches. I'm going to go back to Chanzel and just this registration deadline in regards to the end of March and my information officer. How do I avoid not getting the fine?
Okay, so we've got a registration deadline. Each company needs to register with the information regulator. So you need to register your information officer with a regulator before the 31st of March. If you aren't registered, fines will be given to you as CEO, not the company. Remember, fines are given to us as natural persons and not for the company. So it's of the utmost importance that you get registered before the 31st of March.
Thank you. So the process of registration this information officer, again, we've looked at the process and this is what we've come up with. So first, it would have to be a board resolution where the board then confirms the information officer. We've got those resolutions ready. Then there's the appointment of the information officer. And this appointment is not only an internal function like a board resolution, but you must indeed interact with the register or the registrar then and register that person using the specific format for that. Included in this registration, I find it difficult to understand why the information officer registration is March, but then I have until July to file all those plans. I think you can do all of this at once and get that finalized. You may appoint an assistant information officer. Our entity is called SmartBot that we will be utilizing to interact, to keep the files up to date, to report to the information officer, and to interact with the information regulator. So to make sure that all these board resolutions and all these policies are filed and correctly kept up to date. If this is not an outsourced function, then the information officer takes personal responsibility for that. Data collection. So data is collected on various platforms. And I'm using the differentiation, or we are, between the cyber world and the real world. So from a website, your domains, your e-commerce, that we must definitely, if you've got an e-commerce website, you need to be more vigilant. The cookies that you're using, the website protection, and your POPI policy in regards to this. The irony of this is that you get this software that holds your ransomware, that holds your website and data ransom. It's a double whammy, because not only will you be dealing with the ransom, but you will also immediately have to report that as a cyber breach. Other cyber data, data collected from WhatsApp and WhatsApp itself, Telegram, Teams, LinkedIn, MailChimp, all of these things do constitute cyber data. What is interesting, if you read the Act, and we'll deal with that if we do assist you, if the information, and I'll take MailChimp as an example, MailChimp, the information that you keep on MailChimp is not held in South Africa. MailChimp is an American company, which means that your data has floated out of the borders of South Africa and sits in another country. And in terms of the POPI Act, that is not allowed. That is why Microsoft was very quick to set up direct offices in South Africa and to set up their backups or whatever happens there in South Africa to comply with the POPI Act. Real world data, a bit more easier. I mean, this is of course the direct warning form, the direct stop order form for the union, the direct application to a provident fund or medical aid, whatever the case may be, but tenders, personnel file, job applications, and invoices. These are the basics of how my clients would be collecting their data, and we need to monitor that and make sure that there are no obvious loopholes in that collection. Cyber data, where is it processed? How and when is it stored? Backups, access, password, and is your IT outsourced? If it is outsourced, then that person will have to give you their POPI, and my IT is outsourced, so then they will have to give you their POPI policy so that you can show that in backtrack all of these things are put into place, taking into account the information officer is responsible to count forward and to make sure that he has a policy to deal with all of this. Real world, are you filing it or you're just keeping it in the open drawer? How is it protected? And how is the access control detailed? So that would be a physical break-in where they would come and steal files. Data destruction policy. How is cyber data destructed and how is real world data shredded and destructed, whatever the case may be. Specifically, us lawyers, attorneys, doctors, I mean, your real world data could quickly lead to identity theft. So you need to have a destruction policy. Security safeguards. Back to Shanza.
Okay, security safeguards. Firstly, you need to have security measures in place to protect the identity of your personal information to prevent loss. Secondly, information processed by the operator or person acting under authority. So this is specifically your contracts within your HR manager's office. So you need to protect that. Then security measures regarding information processed by the operator. So that is a responsible party. They must ensure that the operator establishes and maintains all security measures, specifically your tenders. They must notify the responsible party immediately when there are reasonable grounds or information that they believe that has been accessed without the needed authority. Then a notification of security compromises. So this is a big one. You need to inform the regulator. You need to inform the data subject. The notification must be done as soon as reasonably possible. And then you can only delay your notification if once the regulator determines that the notification will be part of a criminal offense or a criminal investigation. And the notifications must be in writing.
So what we have done is we've looked at this, and this is the solution that we propose. We do a preliminary online assessment and report. And because your clients, we're not being funny about this, here are the prices already set out. The online cyber assessment and the report. From that, we can already collect and see where we are going and what you should be complying with. The preliminary inspection, resolutions and appointment, the board resolutions, the necessary documentation to register the information and or deputy information, the on-site inspection checklist, and the company organogram. So these are all done by us. The optional extras would be if you were to ask HR bot or ourselves then to manage the interaction with the information register and to appoint us as the deputy information officer. So those prices are available on request. What is of the utmost importance would be an objective third party, which we send out. And this, if we say a half day, it can actually take more than that, but this would be our fee to come and do a real world assessment to make sure that which is reflected in the online assessment was not inadvertently transgressed, to do a cyber world assessment after that cyber assessment. And that is why we send a IT specialist included in this just to come and have a look. And they provide reports that you can provide to your IT people to make sure that they comply and not do funny things and assure you everything is okay, but it's not okay. And then you get a full compliance report, and that full compliance report would then include any combination of all of these policies that you may or may not need regarding the size of your company and how you deal with your data. So we will provide all of these policies as part of that. If we are the assistant information officer, that is what will be filed with the information register. Phase 2 would be 2 to 4 months in the making. We've got to show that we are trying. So your 6-month follow-up and site visit will be to double check and make sure everything is done. And phase 3 of data processing and automation will take place at a later stage. So that will be your compliance, and we avoid any of the risks in regards to any of these fines that may be implemented in the future. And that brings us to our question and answer session. So I'm going to ask if you have a question, jokingly, in the real world, you can unmute yourself and ask a question directly. Otherwise, you can post them in the chat box. I'm going to deal with the chat boxes first. Let's start here. The information officer, must it be a South African citizen or can it be a South African permanent resident? Now, that is a good question. Shamsal, have you got the answer to that?
I was trying to look it up in the Act as well. So the Act specifically states an SA citizen. I was looking at what is the difference between a permanent resident and SA citizen. So the basic and the majority of the information that I could find was to say that if you are, as a permanent resident, you have most of the rights and responsibilities of a South African citizen, but you won't be able to obtain a South African passport, and you also don't have voting rights in South Africa. So I'm gonna have to get more information regarding that. But at this stage, what I'm seeing and what according to the Act, they say just South African citizens. So let's leave it at SA citizens for now.
Thank you, Shamsal. Always good to have a great team assisting you. Nisa, she's the HR manager running a big construction company. Third-party sharing, does that include our health and safety files on our building sites as well? Absolutely. And not only is that personal information, but that would fall into the category of special personal information. So you would have to make sure that your health and safety outsourced company provides you their POPI everything, including the information officer and all the policies that goes with that. You will then add that to your file as you would add my stuff, which I will be providing to my clients, so you can file that. Will you be able to check and inform the company of which policy is a company need to have out of all of these? Absolutely. So part of our duties would be to look at the plethora, that's a big word for many types of policies that are referred to in the Act, but not all of them will be applicable to all companies. So it would be part of our duty to say which ones would be applicable and to personalize that to your company for the information officer to implement. Is it possible to get the recording? Absolutely. So this recording will be available as well as this PowerPoint. What is the process for a single company with multiple divisions? These divisions are on different properties and separate operating systems. What is interesting, if you have, and now the question about franchises has arisen. So if I am a franchisee, can I rely on the franchisor to sort out all of this? And the answer is no, because if the entity, be it now PTY, sole proprietor, or CC, that individual that is linked to that entity must comply as a natural person. So, Ari, I've got 5 entities and I'm involved with a few others, so I need to file 5 plans, even if it's different operating systems. As LabCo, we're not going to be funny about it. If you have more than one entity and the same, we found that a lot, that the same laptop, the same iCloud backup, the same documentation and hardware is being utilized for various entities. So then each entity would have to comply, but you'll file the same plan using the same serial numbers of all the hardware, even though they are used in different entities. Does this include information required by other government organizations, i.e. we need to send our database to SAQA? Do we need to advise our database that we do this? Absolutely. You would have to adopt a policy to inform your clientele, in this case, scientists that you are managing, that you are by law sharing their information with a third party, and that would now be a third party user, regardless of whether it's government or not. Does this affect IOD claims and get first medical report from doctors? That is a very good question. That doctor is already not happy that he has to treat an IOD and has to wait for his money from the Compensation Commission. So he's not going to give you any POPI compliance documentation. I would have to say on that one, I would, as an employee, in the contracts of employment, I would have to say that your information regarding IODs, medical clearance certificates, your use of sick leave, whatever the case may be, is being collected and is being shared with third parties. And I am informing you of this in your contract of employment. That should cover all the bases in regards to that. Any questions that you have received from email or SMS?
Not that it's already been discussed here. Just one interesting fact is that it is not only private entities that have to comply with this act. Every single public entity also has to comply, which means every single public department in this country is going to be doing or has to do exactly what we as private institutions to comply. So this is not just a one-sided law that only covers private entities. It also covers public, and it's going to be very interesting to see who comes out tops, knowing our public sector and their standards. So other than that, no, I don't have any other questions that hasn't already been covered.
I see I've got a question regarding Facebook and other social media marketing. Very problematic. Facebook and WhatsApp, which we are utilizing as in our entities, there's no indication that their information or backups are being held within the borders of South Africa. So technically speaking, it would be a transgression of the POPI Act to keep company or private, not your own data, that's of course your prerogative, but any other data on those platforms. And if you were to share, and it is so easy to share, here are your draft court documents, and I WhatsApp it to my clients, I am sharing quite a lot of personal information in that event, and I would have to think twice about how I'm going to share my information going forward. But yes, Facebook and social media marketing will be taking a serious knock, and we need to be careful if we are utilizing those. Chanzel, any questions or queries that comes to your mind?
No, nothing.
Well, if the specialists have no queries or questions, I know this is a bit of an overload in regards to what needs to be done in a relative short period of time. So please look at the recording, look at the PowerPoint, see what we are doing, and you can at any stage call on us, and even if it's just for advice on how to deal with this on your own, more than welcome. If you would like a solution to be provided, that's what we aim to do. Thank you very much. Yes.
Sorry, may I just ask, I have taken a list of everybody that was on the webinar today. As far as I have email addresses, I will send the PowerPoint out. If you do not get the PowerPoint, please, will you email our offices, admin@leolaw.co.za, request it. And then I will also mention on the PowerPoint that I send out, but if you want a copy of the recording, if you can then just reply back on that mail and ask for a copy. I don't particularly want to send it out to so many people if it's not necessary, because it is going to be quite a big file. So please, admin@leolaw.co.za. Any questions? If you didn't want to ask anything today, if you need the PowerPoint, if you didn't get it, I will gladly assist.
Okay, so I'm just going to give a second. If we don't have your contact details, just take a screenshot of the contact details so you know how to contact us. Thank you, everybody, for your participation. Thank you for the team for setting up not only this presentation, but also working hard at the solutions so that we can comply for this. Thank you very much. Thank you.
Thank you.